Hello, everyone. Welcome to the annual conference of the Amsterdam Center for European Law and Governance, also known as ACELG. And most of you will know what ACELG is, but I'll say a couple of things anyways. My name is Giacomo Tagiuri, and I have the honor to serve as acting director of the Research Center, and I'm delighted to welcome you here on behalf of all our group. The Amsterdam Center for European Law Governance is a research center at Amsterdam Law School dedicated to the study of European law in close conversation with other disciplines, as today's conference illustrates. Its mission is to make contribution to academic and policy debates about legal and governance processes of Europe. The researcher affiliated to our center have very different research interests, from EU constitutional law to market regulation, from migration to environmental law, from gender to history and the cultural study of law, competition law, and economic regulation. But despite this diversity, every year we try to come together and have an annual conference, which is of sort of horizontal, transversal significance and appeal. We are very proud that our conferences are typically very interdisciplinary, and this year I think is also the case. The theme this year of our conference is Regulating Europe Under Uncertainty. Indeed, as the title evokes, there is widespread sense that we are in a moment of profound uncertainty for the EU and for EU regulation, linked to both external pressures, new geopolitical tensions, and new interdependencies as revealed by the Russian invasion of Ukraine and Trump's tariffs, and also linked to internal political and legal development, a push for simplification and deregulation, and the well-known attacks and rejections of liberal values, supranational institutions, and expertise, which go under the heading of the backlash, something we also discussed today. All these in a context in which there are regulatory challenges for which getting the regulation right is very urgent or even existential, like climate change or novel technology like artificial intelligence. So uncertainty describes the present moment or context in which the EU exists. And in turn, and this is also the second observation animating the conference, uncertainty also evokes a style of EU regulation that has been celebrated as capable of dealing with complex regulatory problems. A style of regulation which does not accept fixed hierarchical solution, but indeed embraces and master uncertainty through flexible rules and the transnational setting. So uncertainty as a threat, but also uncertainty as a condition for governance innovations to emerge and flourish. That's the sort of double observation behind the conference. This is reflected in our panels. Some panels trying to unpack, and Jonathan's keynote, of course, will say a lot more. Some panels try to unpack this uncertainty as a conditions for governance, and other uncertainty as a challenge, uncertainty as a threat. The question we ask a bit to reflect with the present moment is, are these contemporary challenges fundamentally new? Are they so insidious to challenge or threaten the style and ambition of EU regulation? Can the EU sustain its regulatory model, and how must it adapt to survive? This is sort of overarching. Tomorrow, we look at specific sectors where this plays out very clearly, like competition law and regulation, and climate and green transition. I'll stop here because Jonathan will actually say much more and enrich and complicate this framing. Just a couple of acknowledgements. I want to thank Alicia van der Werf for organizing this and pushing me so that the conference happens and happens in time, and all my colleagues who sort of exchanged with me, in particular Kati Cheres, with whom we've invited several speakers, and Jonathan Zeitlin himself, to whom I pitched the idea early on, and you were immediately supportive. So thank you for that. In terms of logistics, we now start with Jonathan's Zeitlin keynote, who I'll introduce in a second. It will last for around 1 hour and 15 minutes with Q&A. Then we'll have at 3 our first panel, Regulation and Governance Under Uncertainty, a coffee break, and then at 4:40 our second panel and last of the day on varieties of backlash to EU regulation. And tomorrow, again, a very rich program, so please have a look. We'll announce more tomorrow. Well, Jonathan Zeitlin needs no introduction, but perhaps for our students or for those who are new to this setting, Jonathan is Emeritus Distinguished Faculty Professor of Public Policy and Governance in the Department of Political Science at the University of Amsterdam and the founding director of ACES, the Amsterdam Center for European Studies, a center with which we collaborate very closely. Currently, Jonathan is in between Amsterdam and Florence, where he has appointment at the Robert Schuman Center for Advanced Studies of the European University Institute and also Scuola Normale Superiore. Before Amsterdam, Jonathan was for many years a professor at the University of Wisconsin-Madison, where he was director of the European Union Center of Excellence. It's impossible to capture the breadth and depth of Jonathan's contribution to many fields: European studies, political science, public policy, business organization, and business and technology history. So his contribution to all these fields are very rich. Let me just say for today's conference that Jonathan, the core of his current work is on new forms of experimentalist governance in the EU, and is one of the scholars who has shaped the framing of experimentalist governance, including in the EU. I want to just start that we're very happy to have Jonathan back at ACELG because you're not only an affiliated member of our research center, but always a big supporter of our research center throughout the years. You've supported us in many, many ways, so we're very happy to welcome you back here. The keynote you will deliver is titled Regulating Europe Under Uncertainty, Integrating Conception and Execution Through Recursive Joint Governance. Jonathan will speak for around 45 minutes, and then there will be Q&A. Thank you.
Thank you, Giacomo, for the generous introduction, also for the invitation. Can people hear me? Do I need to use the mic? Won't bother. It's a special pleasure to speak to the ACELG Annual Conference. I have a long-standing attachment to ACELG. I may still be the only non-lawyer who's a member of ACELG, but I have benefited from my participation in this center. Okay, let me say as well that this talk draws on joint work with Charles Sable from Columbia Law School, but at the same time, I alone are responsible for all the formulations, possibly not all of which Chuck would agree with. Okay, let me start. I'm evoking the conference framing. So as the prospectus.
To interrupt, because of the video, I think it would be great if you could stand here if you want. Yes, is it better?
Better?
Fantastic.
Bring the coffee over here with me. Okay. So, I mean, the conference prospectus rightly begins by stating that the EU is widely recognized as a global regulatory powerhouse. Brussels effect has become notorious. I'm not sure why that has become the term to express it, but it does communicate. Okay, a global regulatory powerhouse, not only for the union's reach and ambition, covering a seemingly ever-expanding set of policy fields and issues, but also for its innovative governance model based on open-ended principles and flexible rules promulgated, implemented, and regularly revised through multi-actor processes of experimentalist deliberations, is the expression governance that Giacomo invoked a moment ago. But as the conference framing also rightly remarks, EU regulation is coming under increasing pressure. Some of this is coming from outside, obviously the Trump administration, but also, and perhaps a little bit more surprisingly, from within. The Draghi report and the current Commission's simplification agenda are key cases in point. I'll say more about them. And internally, there is an influential discourse that regulation has become a drag on the union's competitiveness and innovative capacity, and that this in turn may endanger its geopolitical security. I want to start by questioning that framing in the current political debate within the EU. And I want to ask, where's the evidence? Where is the evidence that EU regulation has, in fact, contributed materially to reduce the competitiveness of the European economy, relative in particular to that? There's another discussion about China, but regulation is not part of it in the same way that it is vis-a-vis. Now, I think it's important to read the Draghi report carefully. If you read it carefully, the picture that the U.S. is strong in high tech and the EU is strong only in mid tech, it can be quite qualified, because within the Draghi report itself, you can find significant clusters of innovation in high as well as mid-tech sectors. I think of pharma, of telecoms, of quantum computing, and chip making equipment, among others. More or no less importantly, the report provides very little concrete evidence to support its headline claims about the salience of regulatory barriers to investment and growth in the EU. Now, if we look through it and say, okay, well, what does it actually talk about? The point which has been most quoted is that according to a survey conducted by the European Investment Bank, more than 60% of EU companies consider regulation to be an obstacle to investment. Sounds very significant. But the Draghi report fails to mention that fewer than half of these companies considered regulation to be a major obstacle to investment. And they conducted a survey of US firms using the same questions and methodology at the same time. And these were more likely than their EU counterparts to report regulation as an investment barrier. And here is a chart taken from that EIB report. And here you can see the headings, the bars that I've highlighted in yellow are labor market and business regulation. You can see the dark blue is the proportion of companies that think it's a major barrier to investment. You can see that that's less than half of the total who think it's a problem. And you can see that if you sum the two up, the US levels were higher on both counts. And you can also see that other issues, including uncertainty about the future on the right, and availability of skilled staff and energy costs, this was conducted in 2022, 2023, were clearly considered more important by everybody concerned. So this is it's certainly not something that can explain, let's say, a competitiveness gap between the EU and the US. Now, what about the Commission's simplification agenda? This, in turn, in the second von der Leyen Commission mandate, has been legitimated by reference to the competitiveness analysis of the Draghi. But we start again to look at this more closely. It's striking that the first omnibus package focuses on legislation that hasn't yet come into effect: the corporate sustainability due diligence requirement, the corporate sustainability reporting directive, the CBAM, the carbon border adjustment mechanism. And obviously, this can't have contributed to past competitiveness gap. And if we look at other upcoming omnibus packages, many of these target sectors like farming and chemicals, which are not flagged as regulatory reform priorities by Draghi. And for example, as Alberto Alemano has very prominently pointed out, these proposals are not accompanied by impact assessments. So the requirement to show that the claims behind them are justified matter and how much they matter, and what their costs and benefits are, has been sidestepped. So basically, if you want a nutshell analysis of the simplification agenda, I think we can see it as arguably more a response to populist pressures in member states, which are linked to the domestic backlash against the European Green Deal that we'll hear more about in a subsequent panel, coupled with heightened geopolitical anxieties of EU leaders in the Trump era. And these together, that is the populist backlash and the leaders' anxieties, have empowered business lobbying. So now we see businesses coming to the EU with a wish list of things they don't want, then to any kind of evidence-based critique of EU regulation. So I think it's more a political and geopolitical issue than any question of actually how is EU regulation working. And I want to emphasize a kind of paradox. So on the one hand, we have this increasing political pressure on EU regulation, but at the same time, the governance processes, decision-making, procedures, methods, and outputs of EU regulation have been rapidly evolving in innovative ways that enhance the union's capacity both to address long-standing problems and to tackle new challenges. And I would say here again, I'm foreshortening in the interests of time. These transformations, in turn, can be understood as a widespread response to three fundamental trends. The first is rising uncertainty, technological uncertainty, commercial uncertainty about products, markets, and consumer behavior, geopolitical and geoeconomic uncertainty. Secondly, heightened interdependence within the EU, connected to the single market and to aspirations to expand it further beyond the EU in terms of transnational supply chains. And very importantly, and in some respects, particularly specific to the EU, is persistent diversity, socioeconomic and institutional differences among member states. Now, if you take all these trends together, this calls into question not only conventional types of hierarchical command and control regulation, which we've been bashing for a long time, but also previous forms of experimentalist governance, which I'll abbreviate sometimes as XG, as analyzed in my own work and those of other colleagues. So what I want to claim now is that rising uncertainty makes it increasingly difficult for regulatory authorities reliably to predict future states of the world, to anticipate emergent threats, and to formulate effective rules and procedures to address these threats in advance. So responding to these ensuing challenges under conditions of heightened interdependence and persistent diversity, which the EU finds itself in, means that rulemaking, and understand more abstractly as conception, and rule implementation or execution need to be more tightly integrated in order to facilitate rapid revision of rules and procedures in light of experience with their application in different local contexts. And that's the recursive dimension. That is, you make a rule, you implement it, and you feed back recursively from the experience of implementation into rapid revision of rules and methods for implementing them. And in the EU setting, this means that member state actors need to be increasingly closely involved in the design of rules and procedures, while EU actors, on the other side, need to be increasingly engaged in their implementation and enforcement. And this closer and more continuous interaction could be said to undermine the classic model of what is called, especially in EU legal studies, executive federalism, based on a clear division of labor between the two levels of governance. I think it's still true. Lawyers are typically taught that rules and policies are established at the EU level, okay, by the member states and the EU institutions, and then mostly they are implemented by national administrations under the under a sort of EU supervision. And that idea, even if it's seen to be cooperative, is executive federalism. It's precisely the kind of separation between these two levels of governance that I want to argue is being challenged by increasing uncertainty and the integration of conception and execution is a response to this. Now, I think it's also fair to say that these same trends also challenge elements of the classic experimentalist governance architecture. I and other colleagues have promulgated the idea of a kind of four-step or four-element architecture, a kind of iterative multi-level cycle of framework ruling, provisional goal setting at the EU level, discretionary implementation at the member state level, followed by some kind of peer review, and then periodic revision both of local implementation and of central rules and procedures in light of one another. That's the classic architecture. Now, in response to these challenges, I've argued that the EU has been moving many regulatory policy domains towards what I call a tighter experimentalist governance architecture based on more intensive and continuous forms of joint governance between union and member state actors. Now, in a couple of papers with Bernardo Rangoni, we've argued that these tighter experimentalist architectures are crucial to reconcile the EU's drive towards more uniform rules at any given moment, which are seen as needed to avoid regulatory arbitrage and ensure a level playing field under conditions of high interdependence, with, on the other hand, persistent diversity. So securing political buy-in from member states towards these more uniform rules at any given moment. But what I want to argue here, it's implicit in the work with Rangoni as well, but it really comes out more strongly in the work that Sable and I are currently doing, is that this kind of tighter architecture is even more critical to support rapid recursive revision of rules and procedures under conditions of high uncertainty by combining detailed local knowledge with central monitoring and comparative review. Okay, so I've given you first, let's say, the setup of the debate in terms of the current challenge to EU regulation, and then a kind of theoretical or analytical framing about how EU regulation is responding to these challenges. So here's what I want to do in the rest of the talk. First, I want to outline the new forms of tighter experimentalism through recursive joint governance that have been emerging in key sectors of EU regulation over the past 15 years or so. Maybe the global financial crisis as a kind of caesura here, and then the contribution of these new forms of governance, of regulatory governance, in responding to rising uncertainty by integrating conception and execution. Now, what am I going to be talking about? Mostly EU agencies responsible for product and market regulation, especially in domains like medicines, mediation, energy, and finance. But I will also give some examples from more loosely structured regulatory networks and policy fields like competition and food safety. And you'll see that there are some things I talk about which are not formally agencies in the setting. I'm not sure how much that matters. Okay, then the next step is so first I'm going to talk about the governance structure and characteristic modes of operation of these new forms of experimentalist regulatory governance. Then I want to show how in a number of key areas, these have led to effective methods of catastrophe avoidance and crisis response. And I want to argue that these compare favorably with those of their US counterparts even before the Trump era. I mean, today, the US, or at least the Trump administration, is trying to dismantle the US administrative and regulatory state. The contrast is only growing greater. And then finally, in conclusion, I want to briefly examine what could be called an exception that proves the wider rule, an EU regulatory field which has not evolved in the direction of tighter experimentalism and recursive joint governance. And it's also a field whose performance compares unfavorably with that of its US counterpart, and which, unlike all these other areas of regulation, has indeed arguably contributed to the disappointing, innovative, and competitive performance of the sector in question. And this is automotive type approvals and emission standards for cars. Okay, so let me start with sketching the evolution that I discern. I'm going to start with the joint part, so telling you about how regulatory governance has become increasingly joint, certainly between the member states and the EU institutions, but also in some respects between regulators and regulated entities. And then in the second part, I will focus more on the recursive dimension. Okay, so if we look at EU regulatory agencies and quasi-agencies, their key decision-making bodies are dominated by national authorities, what they're called regulatory authorities or competent authorities. There's always some participation by the Commission, by the European Parliament, sometimes by the ECB, sometimes by other stakeholders like doctors and patients. So sometimes these are called management boards in the medicines, aviation safety, food safety agencies. Sometimes they're called boards of supervisors in the banking and securities and markets authority. Sometimes they're called boards of regulators in the energy and telecommunications agencies. If we look at the single supervisory mechanism for banking union, it has a supervisory board. If we look at the new anti-money laundering authority, it has a general board, but they're composed in the same way. On the whole, there are also appointed executive directors or boards, but these have limited powers. If we go on to their decision-making, we find that in most of these cases, all major decisions are taken by the member state-dominated governing bodies. There is an aspiration towards consensus, but normally, if consensus can't be reached, votes are taken by simple majority or supermajority, depending on the issue. A kind of recent and partial exception is that in this new anti-money laundering authority, which directly supervises large, complex cross-border financial institutions, the enforcement decisions can be taken directly by the appointed executive board rather than the board of by the general board. But even there, the general board has to be consulted, and where there are disagreements, a reasoned opinion by the executive board has to be published. Okay, I'm going to go through a series of different critical functions, rulemaking. So in addition to advising the Commission on the adoption and revision of proposed legislation, these agencies often draft binding secondary regulation. Sometimes these are delegated and implementing acts, which hopefully, as EU lawyers, you're all familiar with. Sometimes they're so-called regulatory and technical standards that have a similar binding function. In energy, there are framework guidelines for network codes and things even more detailed and granular binding standards called terms, conditions, and methodology. Now, I think it's quite important to underline that these draft regulations prepared by the agencies are subject to extensive public processes of stakeholder consultation, normally following a formally codified procedure with an obligation to respond to major comments received. And where agencies do draft formal secondary regulations, the Commission can't just change their proposals without prior coordination with the agency. And again, they have to give explicit reasons for any disagreements. And outside of financial regulation, when these things are directly applicable, draft implementing acts must also be approved by a comitology committee of national representatives. So here again, we see the key role of national actors bound up in the story. In some fields, these bodies also take authorization decisions. In aviation safety, EASA issues so-called type certificates for new or changed aircraft, and this includes certification and compliance programs agreed with the manufacturer. This is actually an interesting case because the Commission doesn't need to approve it. The agency can take the decision by itself. In medicines, the EMA recommends EU-wide marketing authorizations of new drugs, and this includes the product information that tells what the drug is supposed to do, restrictions on who and when it can be used, and very importantly, and I'll say more about this, so-called pharmacovigilance planning for post-authorization monitoring and review. The formal decisions about these authorizations are taken by the Commission, but it must provide a reasoned explanation of divergence from EMA recommendations, and it still needs to get the approval of a comitology committee. Now, those are product authorization decisions. In banking supervision, decisions on the authorization and withdrawal of banking licenses, as well as the appointment or removal of directors and acquisition of so-called qualifying holdings, is taken by the SSM Supervisory Board. It's based on a proposal from a national competent authority where the bank is headquartered. Very importantly, any negative decisions must be discussed in the Supervisory Board, where they can then be debated and challenged by national representatives. A third level here is guidance. So agencies increasingly rely on various forms of so-called soft law guidance, which can be directed both at national authorities and at regulatees, that is, businesses. Now, we can understand this guidance has become increasingly important in EU regulation, but not only in the EU, as provisional rules or advice on how to comply with formal rules in the expectation that these may need to be revised in fast-moving regulatory environments under conditions of high uncertainty. More uncertainty, more guidance. Now, I mentioned that people still talk about this as soft law, but it's not clear how useful that category is because many these forms of guidance involve what can be called rebuttable presumptions of compliance by addressees. So if they don't, they have to explain why public or they may be required to demonstrate alternative means with equivalent effects for complying with the regulatory standard. And just like secondary regulation, guidance documents with presumptive force of this kind, typically adopted through extensive public stakeholder consultations with an obligation to reply to major comments following formally codified procedures. And Paul Craig, who we called the Dean of EU and Comparative Administrative Law, has said that he considers these to be superior to US notice and comment processes, which were first introduced by the US Administrative Procedure Act in 1945. And according to the latest jurisprudence of the CJEU, agencies can issue guidance on any issue within their broadly defined mandate, which can be seen as necessary to advance their objectives, even where the right to issue this guidance is not specifically enumerated in their founding regulations. And this is what I think you could take from the recent FBF judgment in banking. Now, if we look at how do these agencies typically prepare their decisions, we find that whether we're talking about rulemaking, authorizations, guidance, they typically work through committees and working groups of officials and experts from the national authorities, together in some cases with EU officials and external stakeholders. So let me just take two important examples. In medicines, drug authorization recommendations by the EMA are taken by consensus or, where necessary, majority vote by committees of member state representatives. This is based on a risk assessment, which is led by rapporteurs from 2 member states, and it draws on experts from their national agencies. It's then peer reviewed by other member states. There is input from the Pharmacovigilance Committee, which needs then to follow up the authorizations. And then there is a hearing with the applicant, who is the manufacturer, in the full committee. So there is a debate. The members of the committee ask questions of the manufacturer and how they assess the manufacturer's reply conditions the decisions that they take. In the single supervisory mechanism for banking union, all major policies and initiatives, that includes preparation and revisions of the supervisory manual and the operational guides, are developed through joint working groups, task forces, and drafting teams. They're typically convened by divisional networks of ECB banking supervision, but they're often led by national competent authority officials. And here is where I think we see sites for what we could call mobilizing distributed expertise and knowledge of national authorities, orchestrating what Sable and I have called learning from difference through comparison of domestic practices, and then building consensus across diverse member states. So that is, broadly speaking, the joint part, or the joint governance part involving the member states and the EU institution. Now I want to talk about the recursive dimension. I want to start with recursive interactions with regulatees. So I'll give you 4 examples. In aviation safety, oversight of regulated organizations by EASA, the National Aviation Authorities, is based on mandatory safety management systems involving risk identification, mitigation, and verification procedures, which are devised by the regulated organization, as well as mutually agreed certification and compliance programs I already mentioned. In food safety, oversight of food businesses by national inspectorates and the Commission's Food Audit and Analysis Directorate, what used to be called the Food and Veterinary Office, is based on so-called hazard analysis of critical control points or equivalent plans. And then where a business is found non-compliant, that triggers follow-up monitoring of corrective actions. In medicines, we have two types of interaction. First, scientific advice. So the EMA provides tailored advice to firms on developing and testing new drugs. There is an intensified, more back and forth, faster during the accelerated approval process for what are called priority medicines under the so-called PRIME scheme, focused on products that address unmet medical needs like orphan medicines. And then even during the approval process, there is what's called pharmacovigilance planning. So all drug authorization applications must include a risk management plan aimed at identifying and monitoring potential risks. These include mandatory post-authorization safety studies and periodic safety update reports, and more broadly, provisions for review and revision of the authorization whenever new information becomes available. Now, I want to also emphasize how this kind of recursive interaction works in, broadly speaking, competition and sectoral market regulation. So in competition, there has been a growing use and generalization under the European Competition Network Plus regulation of monitorable commitments by firms to meet competition concerns raised by regulators under conditions of uncertainty. These are typically market tested through open consultation with competitors to expose potential limitations. And sometimes it's done at the European level, in which case it's the Commission, sometimes at the national level, but the regulator retains the option to issue a conventional decision in case of non-compliance or unexpected negative outcomes. And here I want to draw attention to the contribution of Yanis Fetiev, who is really, I think, the person who has analyzed and taught us about why these commitment proceedings are an experimentalist form of competition regulation under uncertainty. And we find this being extended in other areas. So, for example, the 2018 Electronic Communications Code Directive states that in telecoms, undertakings with significant market power may offer national regulators commitments regarding access to or co-investment in high-speed networks. And also in the Digital Markets Act, the DMA, basically the gatekeeper platforms are required to produce declarations explaining how they plan to comply with the DMA's obligations in a kind of regulatory dialogue, as it's called, and to propose remedies when the Commission finds them in violation. So it can be, and this is also true in competition, that when a violation is actually found, you have a commitment like follow-up in which the firm or groups of firms that's been found in violation has to come up with monitorable commitments for how they're going to remedy the problem. And then the Act also talks about formal commitment procedures to be adopted in case of systematic non-compliance. We haven't reached that yet. It's still early days. Okay. I now want to talk about joint inspection, auditing, and enforcement. And from the point of view of EU executive federalism, the involvement of the EU agencies and authorities in inspection, audit, and enforcement is precisely something new that's attracted a lot of attention. So let me take aviation safety. The idea of continued airworthiness of planes is a shared responsibility of EASA and the national authorities. The national authorities issue and review so-called airworthiness certifications under EASA standards. EASA may conduct conformity investigations either directly or through the AAs. In cases of deficiencies, EASA may issue a binding airworthiness directive suspending, amending, or revoking certificates for particular types of aircraft. And some of you may remember the fatal crashes of the Boeing 737 MAX 8. I'll say more about that in a moment, but that is an example of suspension of airworthiness. And very interestingly, EASA and the NAs have established a shared European pool of inspectors and experts for carrying out certification and oversight tasks. And we see this kind of practice also developing in other sectors like food safety, like chemicals, and like medicines. In food safety, national competent authorities were responsible for ensuring that food business operators comply with EU agri-food chain legislation, including these HACCP risk mitigation requirements, by carrying out regular controls and taking action to ensure operators remediate identified non-compliances. The Commission's FAA directive, then, which can be understood as a quality agency, which is supposed to be an independent agency, but for very contingent reasons connected to the BSE scandal, it was made a division of the Commission. Instead, it conducts regular audits of member state implementation and enforcement. These involve site visits to individual national food businesses, and often, obviously, the national inspectors accompany the European inspectors. These audits result in recommendations for improvement. There's then typically a public exchange in writing. You can find it on the Commission's website with the national authority, and it concludes in agreed commitments and follow-up actions. And in case of serious non-compliances, the Commission can take stronger actions with the approval of a comitology committee of national representatives, including market restrictions and product bans for foods it considers to be unsafe. In banking, this is very interesting as well, joint supervisory teams, JSTs, are responsible for direct oversight of large single supervisory mechanism banks. And this includes centrally conduct of the annual supervisory review and evaluation process, or SREP exercise, which covers capital, liquidity, and other regulatory requirements. JSTs comprise a mix of ECB officials and local staffs. They're a little bit more than a third ECB, the rest are local. There's an ECB joint coordinator who's responsible for proposing the annual SREP decision based on standardized but adjustable risk scores, which are benchmarked against those of other similar banks. This is done in consultation with the local coordinators. And very importantly, dissenting views are reported and controversial cases are referred to the supervisory board for resolution. The JSTs are supported by on-site inspection missions, which conduct detailed investigations of specific issues. These are often coordinated across different banks at the same time to enhance comparability and experience sharing. And there's a similar procedure for investigations of banks' internal risk assessment models. And here again, we have a mix of EU or ECB and national officials doing this work. And this model is considered to be pretty successful, and it has been adopted for direct oversight of complex cross-border organizations within the anti-money authority. Okay, I'm going to give you one more set of empirical practices, and then I'm going to cut to the implications. And these are incident reporting and rapid alert systems. And here, this is in a way the most recursive element. So in food safety, national authorities are required to notify immediately through the so-called rapid alert system for food and feed any information related to serious food health risks, as well as any response measures they may take. The Commission can temporarily restrict imports from third countries based on these notifications, can also restrict movements of goods and animals within the EU in agreement with the Comitology Committee. Then the European Food Safety Authority analyzes these notifications, and it uses the results to identify priority areas for EU food safety policy, including new and revised regulations. And recently, an early warning and response system linked to the RACIV has been established, and this includes a Commission-led crisis unit to coordinate responses to major outbreaks, including traceability investigation and post-crisis assessment. In aviation safety, there is a mandatory occurrence or incident or accident reporting system, and this is complemented by a voluntary confidential safety reporting system for whistleblowers and a data for safety program aimed at discovering new or novel risks before they leave the incident. Identification of an unsafe condition or security safety problem can then lead to a proposed airworthiness directive or emergency directive if needed. The provisional ones are subject to stakeholder commitment, comment and response, and this then becomes legally binding across all EU member states. In medicines, systematic reporting of adverse drug reactions by patients and healthcare professionals to the EMA works through a dedicated database, and then it's supplemented by proactive signal detection projects, for example, by analyzing social media traffic about in medicines, there is and this then feeds into an EU regulatory network incident management plan, a pharmacovigilance tracking tool, and then there are procedures for rapid alert notifications through a joint network, and then review of any incidents. And this can also trigger a crisis management procedure, and then it obviously feeds into reviews of existing drug authorizations through the pharmacovigilance system. So you can see what I hope to have tried to show you with all this detail is both how far EU regulation has proceeded towards joint governance between the Union and member states, and secondly, how this goes together with a very intensely and accelerated form of recursion in order to identify and respond to emerging threats. And what I want to do in this next set of slides is to show you what difference this makes. That is how these structures, they're not only beautiful in themselves from an experimental, but they genuinely make the EU in very important ways a safer place, and a safer place which is also good for the European economy. So let me give you 4 examples of how these structures have contributed to avoiding catastrophe and responding to crisis. I'll start with food safety. So I don't know how many of you remember the 2011 Shiga toxin producing E. coli episode. A lot of people got very, very seriously sick from eating what turned out to be contaminated bean sprouts. But since then, there actually have been very few major serious multi-country foodborne disease outbreaks in the EU. When there is an outbreak, it leads to intensive joint assessment by the European Food Safety Authority, but also the European Center for communicative diseases. And then they obviously try to identify causes and formulate new regulatory measures to address them. And so one example of this is the approval, traceability, and certification requirements for sprouted seeds that followed this E. coli episode. In tracing common sources of multi-state outbreaks, especially listeriosis and salmonellosis, which are common forms of food poisoning, the EU has really been pioneering using whole genome sequencing, and this is developed into an EU-wide platform for integrating and sharing data of this kind. I mentioned earlier that the EU has established a general food crisis management plan. This is a response to criticism of handling previous outbreaks, and it combines a kind of ongoing network involving member state authorities, the Commission, and EFSA with a temporary Commission-led crisis unit in the case of major outbreaks. And it's quite striking that if you look at reported annual deaths from foodborne diseases, these are currently 3 times lower in the EU than they are in the US. I need to speed up.
7, 8 minutes. 10.
I'll do my best. Maybe I'll skip through a little bit these slides, because I do need to give you some the exception that proves the rule. Okay, so the EMA's procedures for collaborative development, for accelerated assessment and conditional improvement of priority medicines, which, you know, we have to say they were established in emulation and interaction with the US FDA. They've reduced the median time for approval of this type of drugs to below the US level. These procedures, coupled with the EU pharmacovigilance system, prove crucial in the EU's successful response to COVID-19. They certainly were crucial in fine-tuning the authorization of some of the key vaccines like the BioNTech Pfizer vaccine. And building on this experience, the EMA's mandate was then expanded to cover shortages of medical countermeasures in public health emergencies as part of the broader European health. We see this developing in collaboration with the ECDC, with the Commission, and with member state authorities. Oops. In banking supervision, post-crisis reforms have led to dramatic improvements in capital liquidity and stability of funding ratios. These are now much better than those of their US counterparts, even before the latest deregulation proposals of the US authorities. The average ratio of non-performing loans is a critical ratio of potential weakness, fell dramatically from 8% to 2% between 2014 and 2023. I would say also that this system performed very well in the COVID pandemic as a real-time stress test. So we didn't see an increase in non-performing loans, nor any banking distress or failures. And unlike both the US and Switzerland, the EU did not experience any major bank crises or failures in 2023 when interest rates rose rapidly. There was turmoil in the financial markets. Finally, aviation safety. So I mentioned previously the Boeing 737 MAX 8 case. the EU hasn't had anything like this. In that case, we could say that there was a fundamental unaddressed design flaw, led to multiple fatal crashes. More than 200 people were killed, and maybe more than 300 people. And there was a global scandal involving systematic regulatory failures and corporate wrongdoings. Investigation revealed that the FAA had missed major design safety issues by delegating key steps in the certification process to the manufacturer, Boeing. And Boeing concealed the extent of software changes and failed to provide crucial information and training to airlines and pilots. This led to fines, to criminal penalties and canceled orders. The direct costs, as you can see, were about 20 billion, and follow-on costs 60 billion. And as I said, it's not that there are never air safety issues in the EU, but they have typically involved operation disruptions or singular incidents rather than widespread cataclysmic design failures, and have resulted in more proactive EASA interventions. Okay, now I want, and this will be the last bit before the final conclusions. I want to give you very quickly an exception that proves the rule. This is automotive type approvals and emission standards. And here, what we can say is that the kind of tighter experimentalist architectures based on recursive joint governance are widespread, but by no means universal across EU regulation. In some policy domains, it's still the case that EU regulation remains pretty decentralized, with key decisions left to national authorities, subject to powerful influence of domestic producers under weak union oversight. There are also some domains where US regulators, at least until Trump, have followed a more clearly experimentalist path, developing increasingly stringent technology forcing standards through recursive interactions with regulatees. And I want to say that automotive type approvals and emission standards are a clear case in point. So I don't know how many of you remember the 2015 Dieselgate scandal, but what we can say is that the type approval system for cars prior to 2015, it was based on mutual recognition of decisions by national authorities, relying on tests performed in the manufacturer's own certified laboratories with rather weak EU oversight. And obviously, this led to conflicts of interest, regulatory capture, and venue shopping. And there were long-standing discrepancies between emission performance in laboratory tests and in the under real-world driving conditions. The Commission's Joint Research Council had already signaled concerns that manufacturers might be using special defeat devices to provide a more rosy picture in test conditions than under real-world conditions. And it then turned out that the Volkswagen Group had used these kinds of defeat devices to market so-called clean diesel engines without reducing nitrous oxide emissions, which are very important for health, to meet EU and especially US standards. The fraud was exposed by the California Air Resources Board, which had been strongly focused on vehicle emissions testing and emissions reduction. Since the 70s, it led to massive fines and recall costs for VW. Is the most expensive scandal in automotive history, $30 to $4 billion. I think you can see this as a mirror image of the Boeing 737 MAX scandal in the US, and the role of improperly supervised delegation of certification and testing to the producer is the critical common feature. Okay, since Dieselgate, we have the introduction There have been a bunch of reforms, new harmonized lab and real driving emissions tests, new conformity check rules, separation of member state market surveillance from type approval authorities, new inspection powers for the commission, new powers that haven't yet been applied to harmonize approval and testing procedures. But proposals to create an EU road transport agency were blocked both by the European Parliament and the Council. Instead, you got a relatively weak forum for exchange of information on enforcement to promote best practices and harmonize implementation with kind of limited advisory powers. And even after that, the introduction of new emission standards was delayed and watered down due to pressures from manufacturers and member states. And the EU, even to this day, the EU's nitrous oxide emission limits are still twice as high as they are in the US, and they were 4 times as high until 2020. I want to argue that this has had significant economic consequences. Only Volkswagen was directly implicated in the scandal, but quite a number of other companies were later found either to have used similar defeat devices or to have taken advantage of the weakness of the EU system to understate their true emissions. And here's the key point. Overinvestment in diesel technology, which accounted, by the way, for more than 50% of EU car sales in 2015, contributed to manufacturers falling behind in developing first hybrid, then electric vehicles compared to Japan, Korea, China, and even the US. And so here's a place where there is a technological and commercial lag, which is linked not to stringent regulation, but to inadequate regulation, which has really had a major impact on European economic performance. And the automotive industry remains very, very significant in employment and value added, in exports and in capital investment. To this day, it represents 1/3 of all R&D in the EU. And then there's a further follow-on consequence, which is that the eroding competitive position of this key industry led manufacturers and the member states where they're based to push to delay or even abandon commitments to phase out internal combustion engines. Here again, okay, beyond the effect on climate change and the environment, this is also going to weaken their long-term competitive position. Okay, my conclusions, which I hope you'll find thankfully brief. In many, but not all policy fields, EU regulation has responded to rising uncertainty, heightened interdependence, and persistent diversity by developing tighter experimentalist architectures which integrate conception and execution through recursive joint governance between regulators and regulatees, as well as the Union and member states. These tighter experimentalist architectures have led to effective methods of catastrophe avoidance and crisis response, addressing long-standing problems, tackling new ones in innovative ways that compare favorably with the performance of their US counterparts. The most consequential regulatory failures with negative impacts on innovation and competitiveness, as well as the environment and public health, have come in sectors like automotive type approval, which lack such experimental architectures, and here, sometimes in contrast, those of the counterparts. So the bottom line, the EU, in my view, should refine and extend rather than retrench this successful regulatory governance model in order to adapt to new geoeconomic challenges while continuing to advance the Union's broader objectives and values. Thanks for your patience.
Wonderful. Thanks a lot, Jonathan. We now have around 20 minutes for Q&A. So I would invite anyone who has questions or observations to raise their hands. Yeah, and maybe if you can briefly say your name.